you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay because it could be in my system for a long, long time, even though I don't get high.
And that was just
And I didn't
that was just something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But
system.
you guys don't do
And
it
then-
by levels.
What?
But you don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
You test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story.
Defender Alexis Zerbs on behalf of Ms. Clements, who's approaching. Can you please state your name for the record?
Marquetta Clements.
Thank you. You're requesting an adjournment?
Yes, Your Honor, to engage in some plea discussions, and I'd like to address bond when appropriate.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. Master bond.
Thank you, Your Honor. Ms. Clements is in custody based on a prior failure to appear at a probable cause conference on September 11th. It's my understanding that after this alleged incident took place, she was hospitalized at St. Joe's, and then St. Joe's transferred her to Stonecrest, and she was in Stonecrest from September 9th to September 26th. She was suffering from long-term memory loss. She had a concussion, and she was having some other mental health issues. I did try reaching out to both of the facilities. I sent releases of information to both. I haven't gotten any records back at this time. But once she was released from Stonecrest, she was working with Leaf Harm Reduction. She can either stay with a friend in Ann Arbor, Your Honor, or she can stay at the Delana. She does provide me this address. And
How'd she come back into custody?
What do you brought up?
Officer just took me off the bus, no reason. I wasn't in no trouble.
So, Your Honor, I believe in that.
He just came on the bus and grabbed you?
Asked Officer Lawrence, he did.
Because he knew you had a warrant.
He knew I had a warrant, but I didn't know I had a warrant at the time.
So, Your Honor, with that, I would say that there was no new charges when she was brought into custody. It was just officer recognition and being aware that she had the warrant, so they brought her in on the warrant. Like I said, Your Honor, I'm still waiting back on any of those records, but at this
So I
time,
don't have any medical to verify what you're saying, and she was gone for about 4 months.
yes, Your Honor, but I'm hoping those records will be here very soon. Like I said, I sent releases of information to both
So
St.
those
Joe's.
records aren't going to explain the 4 months. No answer needed. I don't need a response. Motion for bond reduction denied. Bond voted. Thank you. Court calls case People versus Abdul Latif. You know what? You keep talking. You want me to up it? Oh, give me the file. She wants to be smart. You can just let her know her bonds revoked. Mark the file. Court calls case People versus Abdul Latif.
Morning.
Good morning, sir. I'm Senator Daffy Lebo, Mr. Bill Latif. Mr. Bill Latif, can you tell the court your name, please?
Ability.
You need to take your hand out of your pocket. Anything you want to say to me? No, I'm kidding.
Your Honor. Your Honor, we're going to be requesting an adjournment with no complications in order to just finish verifying some discovery.
Okay. I will adjourn this then February 12th, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
There you go.
Thank you, sir. Court calls case People versus Joseph Griffin.
You got that file, Mark.
Good morning, Your Honor. Veronica Glenn requesting permission to practice under pursuant to Michigan Court Rule 8.120, practicing under assistant.
How many times have you
defender.
said this? Come on. You're with Canon, right? Is this the stage fright that's just going through? No? Start again.
Okay. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120, practicing under Assistant Public Defender Stephanie Cannon.
See? Wasn't that hard? He's a
not.
product. Yes, you got it.
Permission to practice is granted.
Thank you. Your Honor, we're requesting adjournment in this matter.
All right. Purpose of the adjournment?
We need additional discovery, or we need a discovery.
You need it.
Yes.
Conference without objections adjourned February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Diamond Buyers, all three cases.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Edward Jupis on behalf of Diamond Buyers.
Diamond buyers.
Thank you.
Your Honor, there's some negotiation going on. There is another case that just is authorized, and then there's another one coming down the pipeline. That's what I was told yesterday. I'm looking for an adjournment.
So, Your Honor, there was another case of financial transaction device authorized on the 26th by our office. There's also one pending in the warrant queue. These all stem from roughly the same time period.
So I've got one. Do we have a date set on the one that was on the 26th?
I don't believe so. Let me check my court to confirm that, but I didn't see one I was earlier. No, I'm not seeing if there's any dates set on. I don't know if it's even this one.
One, two, yeah, okay. All right, that's fine. So basically, I could potentially be, I'm expecting one, but then there may be another one, so there may be two.
There's definitely 4 total, maybe a 5th one.
Got it. Probable cause conference, what I'll do is I'll adjourn this out to February 26th, given all of that. I'll need green sheets.
Okay, thank you.
2026, 9 a.m. Her crime will continue. And I guess so that those are tracking, if the other one does get sworn out, she's arraigned on that one. However that may occur, I don't mind setting them out to stipulate to adjourn it to this date. So I'm putting it out far enough. Hopefully we can get all that on one date.
Okay.
Okay?
Thank you, Your Honor.
On continue. Thank you. Court calls the case of People versus Spencer Norton, 2 cases.
Good morning, Your Honor. Edward Jupis on behalf of Spencer Norton in 1768.
And the Assistant Public Defender, Tanaka Fair, on behalf of Mr. Martin in the other matter.
Good morning, Miss Ackerman.
Good morning.
So you're sitting there and didn't hear a word from you?
She's been talking to me all morning, Your Honor.
She's been in your ear. Okay, I got you. Okay. What are we doing? In your name, sir?
Spencer Norton.
Thank you.
Looking to set ours for an exam. I think the other one's gonna come along with it.
That is correct, Your Honor.
Both set for exam?
Yes.
All right. Discovery is complete on both of these?
To my knowledge.
To my knowledge, Your Honor.
And do people have their witnesses available to 10th? Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Garwood. I would need check the box on here, understanding
Please.
that I'm a different sentencing judge.
That's correct,
You
Your Honor.
understand, sir?
I reviewed that with him, but I failed to check the box. I apologize.
Well, I knew it was your fault. I just want to make sure that he.
Yep.
May I have him sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Adam Atkins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine, one that is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty as charged.
All right. You understand that by pleading guilty, you'll not have a trial or of any kind? You understand?
Yes, I do.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you have those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Pardon?
Yes,
You are? Were you on probation at the time of this offense?
yes,
All right. You understand that this could be considered a violation of that?
yes, Your Honor.
If it is considered a violation of that probation, you could be sentenced to the maximum allowable under those other charge, under that other charge or charges. You understand that?
Yes, Your Honor.
And understanding that, you still wish to plead guilty to this charge.
Yes, I do.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily
Yes, I am.
of your own free will,
Yes,
and also because you believe that you're indeed guilty of this offense?
yes, I do.
On November 20th, 2024, at the location of First Street near Ann Street in the city of Ann Arbor, Washington County, state of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
No.
You were intending on using it?
Yes,
You knew what you had in your possession was methamphetamine?
yes.
All right, I can take to the higher charge in any
Thank you,
event.
Judge.
All right. Sir, I do have to advise you that if I do accept your plea, if you commit misconduct as defined in Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
We are not, Judge.
And have I complied with the court?
Defense is satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be February 17th, 2026. What time? I'm sorry. 9 a.m. before Judge Garwood. Bond will continue. All right.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Austin Bryan.
Morning, Kevin Nagel, appearing on behalf of Mr. Bryant, who is appearing to my right. Your Honor.
Name, sir? Austin Bryan.
All right. Your Honor, I spoke to the people in this matter. I've informed my client of his rights to have a preliminary exam today. We're waiving the preliminary exam, and we'd like to spine it over to circuit court here.
Sir, is that a correct statement? You're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts. Counsel, you acknowledge receipt of the information waiver treaty?
Yes, Your Honor.
And at this time, how does your client plead? Is he standing mute to the charges?
Yes, Your Honor.
Defendant, having waived formal reading, standing mute, court will enter a not guilty plea to all 3 counts. Pretrial will be set for February 10th, 2026, 1:30 before Judge Cuffey.
Thank you, Your Honor.
Bond will continue. Just gonna need to sign off on the whoever. I don't know. Court calls the case People versus Ashley Albert. Who had that last case so that we can sign off on the information? I did.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with on behalf of Ms. Albert.
Your name?
Ashley Olber.
All right. You're requesting an adjournment. You just got discovered.
Yes, Your Honor.
Probable cause conference in this case will be adjourned to February 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
The court calls the case People versus Johnny Kane.
You're ready to talk to the people?
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Payne, Your Honor.
Her name, sir?
Johnny Charles Payne.
Your Honor, this is a matter we have reached a resolution. I'm looking for the paperwork now. I just had in my hands. Here it is. Your Honor, Mr. Payne will be pleading guilty to an added count 2 of use of a controlled substance. I have him executing the plea form and the advice of rights. Now, I have gone over his rights. Here's sign that. I have gone over his rights with him. Get it. And explain to him that all those rights. Your Honor, this is a matter with some labs. There was a true narc analysis. I've seen a picture of the analysis. I don't have the report. I don't know that the labs have gone to the crime lab. I've explained that to Mr. Payne. He still wishes to issue a plea, enter a plea, if I may approach. He is on parole, Your Honor. I've explained to him.
I'll get to it.
Thank you.
The plea form that the court has in its hands indicates that the defendant's going to be pleading guilty to an added count 2 of use of methamphetamine, that the 1-year offense. Upon a successful plea to that charge, count 1, the possession charge would be dismissed. There is prosecutor and defendants agree to a sentence of time served. However, I would indicate that taking the plea, I could not find a sentencing judge to that recommendation. And that, sir?
I do, Your Honor.
All right. I have him sworn.
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Johnny Charles Payne.
Sir, it is this court's understanding you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
I do.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
I do.
Still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I do plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No, sir.
Are you on parole?
I am.
You understand that your entry of a plea in this case could be a violation of that parole.
I do.
You understand that as such, you could be sent back to do the remainder of your term.
I do.
Understanding that, do you still wish to plead guilty in this charge?
I do.
In this case?
I do.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
They have not.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty?
I do.
All right. On the date of December 12th, 2025, location of Barton Drive near Pontiac Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
I did.
Had you used it?
I had.
And did you know what you were using was methamphetamine?
I did.
All right, sir, I do have to advise you that if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not, Judge.
All right, and have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied the court has complied with the court.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 27, 2026, 8:30 before Judge Perry. Bond will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
You're welcome, sir. Court calls the case, People versus Renee Andrews.
Andrew, so the train on behalf of the people.
Assistant Blood Center Deputy Lebo on behalf of Ms. Andrews. Andrews, can you tell the court your name?
Yes, Renee Andrew.
Thank you.
And Your Honor, we're going to be requesting an adjournment. Ms. Andrews is going to be reviewing some discovery with me.
Probable cause conference will be adjourned to February 19th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls cases People versus Kimberly Robinson.
Okay, last of the people.
Veronica Glenn on behalf of Ms. Robinson. Can you please state your name for the record?
Shirley Robinson.
Thank you.
Thank you. Your Honor, we're requesting an adjournment in this matter.
Have a green sheet. So that one can. Basis.
Discovery.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Case of the People versus Jessica Anglin.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Ms. England. Your Honor, I was unable to get into contact with Ms. England. We don't have good contact information from her. It's my understanding that she has some housing insecurities, so I'm not sure if that played a factor into her not appearing today. For the record, I'd be asking for an adjournment.
Does that play a factor in not going to community corrections too?
Possibly, Your Honor.
It's
It is very cold out there. I'm sure she's trying to stay warm.
not cold. This is Michigan. Suck it up. Bench warrants will issue for the defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety.
Okay, last of the people.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Karma. Good morning, sir.
Good morning.
Your Honor, we're requesting an adjournment for discovery.
The adjournment. Have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because, sir, when they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one or the other. But you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me,
Yes.
that on January 5th, you tested positive for cocaine. And that was just,
And I didn't
that was just
expect-
something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But you
system.
guys don't do
And
it
then-
by levels.
What?
But you don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story. And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What I'm
I don't know
saying,
who the heck you are, but if you start yelling in my courtroom, you're gonna be going with her.
Okay, this what happened on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead, think about it.
Right. What I'm saying is, on the 5th, I was dirty. I had used, like, not that far from there. But I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time
So
it was
hold on.
still
That's what I was getting at before your fans started yelling out from the.
my sister. She here
All
from
right, but
out of town.
so you're telling me
Mhm.
this test that showed up positive, you didn't use cocaine,
Which one?
the 20th,
The 20.
last
no,
test.
No, I had.
You had
Since
not
the
used
5th.
any cocaine,
No,
even though you've been using it for years.
right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
I can check levels.
wish
But
y'all
not,
would.
but, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh.
You should not be testing positive for cocaine 2 weeks later. That's the bottom line.
So now.
Grant an adjournment in this matter to February 5th, 2026, 9 AM. That's 1 week out.
Your Honor,
You're not available that day?
correct.
That's fine. I'll set it on the 12th. At this point, the defendant's bond's revoked. She's remanded.
Damn.
What'd you say?
Excuse me. I was saying my
You
sister.
know, you need to take yourself on out. What? What last one? Oh, was it? Did you ever say that?
Want me to repeat it?
No, that was. You don't get that response. No, she's what? You don't want to talk to me about that? No, okay. Court does call the case of People versus Terry Probst.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, who's making his way into the courtroom, I would assume.
Well, where is he?
Exactly.
Evan is custody.
He is in custody, Judge.
Oh,
Just give that back to you. Yeah.
we'll pass it.
Okay.
Court does call the case People versus Quan Patterson.
Freeman Cook.
Cal Kavalowski for the people, Your Honor.
What? Who's that?
That's Mr. Probst.
Oh, I'll just take him if you got him. All right, back on the Probst matter.
Morning, Your Honor. Raymond Cook.
Okay, sign that. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, Your Honor. State your name.
What are we doing? Thank you, sir.
Your Honor, these are going to be waivers. I have gone over his rights. He's executing the form now. I've gone over
Sir,
with Mr. Probst.
You're waiving your right to a preliminary examination.
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that's alleged to have committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further
Yes, sir.
resolution. People also waive their right.
Yes, Your Honor, there was an offer put down on the record.
Yes, go ahead.
The offer was leading to the filing 1391 motion for dismissal of filing.
All right. Good.
That is correct, Rich.
Preliminary examination having been waived in both of these matters. Defendant is bound over to circuit court.
Your Honor, in terms of arraignment, we'd waive reading, stand mute, the charge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for February 11, 2026, 1:30, Judge Conlon.
Your Honor, if I could be heard on bond.
Yes.
Your Honor, I've had a chance to speak with Mr. Probst about this. I've reviewed the file. Mr. Probst was remanded at his last probable cause conference. He had missed some tests and had tested positive. The positive tests, looking at the violation, were from when he was first arrested. He reports he got a personal bond sometime around December 29th. The missed tests, he reports, resulted from a stay in the Wayne County Jail where he was, obviously unable to test. He then reports having gone to community corrections. They indicated that they did not have any record of him needing to be there, and that's why he didn't test on the 29th. I'd ask the court to release him. He does report that he does have a place to stay in gainful employment. I have reached out to he gave me a number. I've reached out to the employer. They haven't gotten back to me yet. So, but that's kind of where things stand, Judge. He reports that he would test regularly in this matter.
That's not what my file reflects, his rendition of things. But most for bond reduction tonight, bond will continue. We'll bring it up. Thank you,
Judge.
Court calls case People versus Quan Patterson.
Alex Jablowski with People.
Is that Mr. Goldston, Your Honor?
No, Mr. Global.
Oh,
Your Honor,
okay, then.
Mr. Kilowatt is on Zoom in another court,
Who?
or I'm sorry, Mr. Goldstein is, sorry. He's trying to wrap it up, so he's not gonna be able to come in for a couple of seconds.
Is this Klein here?
Yeah.
Oh, okay.
Client is here. And I don't have stage fright.
Why are you sending us the messenger? You wouldn't even stand up at the beginning of the docket. Now you're delivering message. No, I don't want to talk to you. Bye. Court calls the case of the People versus Bradley Potter.
Alan Zend on behalf of the people.
Ron Brown, train on behalf of Mr. Potter. Mr. Goldstein standing in for Mr. Fikowski.
Seriously? Okay, we can't, no.
You want me to go get him?
The one you were delivering messages for.
Tell him Bradley Potter's up.
Bradley.
Sorry.
Your name, sir?
Bradley Potter.
Thank you. None of this is your fault. This is.
Goldstein standing in for Mr. Fikowski.
Do we know what they're doing?
Setting exams,
Setting it for exams?
both of them. Mine
Okay,
too.
so based upon your knowledge, the discovery is complete.
That's my information.
And so you want your matter set for exam? Is that what?
Yes,
you're
sir.
All right, very good. Would the people have their witnesses available to 10?
Preliminary examination will be set February 10th, 2026, 9 a.m. before Judge Garwood.
Hey, I just said it for you.
Okay. Bond will continue.
It's February 10th. Judge Garwood.
Thank you.
I'll tell you.
And, all right, thank you, sir. We already took care of it after we got the message from your messenger, Cannon.
She couldn't do the waiver of.
That's what I was saying, but she was delivering messages for people. I don't know what her deal.
Judge, I approach in a related matter to this,
To which one?
Mr. Popowski.
Oh, sure.
I'm standing in for him today, Your Honor.
Your name, sir? Paul Patterson. Thank you.
Your Honor, we do have all the discovery, including the videos, and we're asking the matter be set for free.
People have their witnesses available to March 10th.
Yeah, that's what I said. Is there a problem with that?
I hear it most of.
Your Honor, if I could address bond.
Go ahead.
If I can address bond real quick. My client, the magistrate, for whatever reason, saw fit to place a tether on my client, a GPS tether. It's not a curfew.
We're not sure why exactly. He wasn't ordered to do any testing. I've known Mr. Patterson for a number of years. He's a lifelong resident of this county. He is not a risk of flight. He works in this county. He lives in this county. He has family in this county. So we're not sure why the magistrate, I wasn't present at the arraignment, Your Honor. Not sure why he did it, but we're asking the
Do you have
question.
anything else pending?
No, Your Honor. No. And all I can say about this particular case, Your Honor, is I think whoever the judge at the prelim is going to find the video very interesting.
Give us a moment, we'll get your notices, anything else?
Any response from the people? Those ears, no, go ahead. I didn't know if it was the ears or not. Go ahead, what?
I think that there was, that the tether probably was related to, some recent, at the time of charging, some recent cases that, had been pending or were recently dismissed as exam. There and prior history, I don't necessarily have any other explanation.
That's correct.
You're indicating at the time that the arraignment happened, there was other stuff pending.
Right, which was then subsequently dismissed.
That's what I.
Got it. Okay, with the understanding that there's been a change in circumstance on this, I'll grant the request to remove the GPS tether. So we'll prepare an order and let them know so you can get that removed even before you leave here. Just go over. Okay. I'll set preliminary examination in this matter, March 10th, 2026, 9 a.m. before Judge Garwood. His bond and its monetary amount will continue without fee.
Thank you.
Thank you. Court calls case People versus John Marks.
David I. Goldstein appearing on behalf of the defendant.
Your name?
John Marks.
Thank you.
We're setting this matter for exam, Your Honor. I do have discovery.
People, other witnesses available March 10th.
Do our best, Your Honor.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond continue. Calls case People versus Javante Cadell.
Good morning, I'm Rob Dickel on behalf of Mr. Cadell. Javante, would you state your name on the podium? My name is Javante Cadell. Judge, we're asking to set this matter for exam.
Discovery is complete.
Yes, sure.
People have their witnesses available February 10th.
Do our best, Your Honor.
Judge, may I address bond?
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Fresh Hour. As to bond.
Judge, this young man's 18. He has no criminal record, juvenile record. It's my understanding he was living at Ozone, who was trying to place him with his own apartment. I understand there's a $10,000 bond because he missed a court date. He did not have a ride at that time. What I'm asking the court is, I've spoken to this young man. He promises to appear for all future court hearings. We would like to get back to the Ozone so he doesn't lose his place as far as getting a placement, and he can be gainfully employed. We would just ask the court to set a PR bond in this matter.
Any response from the people?
Your Honor, I'll leave it to the court's discretion. If it helps the court decision making at all, the co-defendant's case that was set for a claim on Tuesday and got dismissed because we were unable to proceed at that time.
Got it. How did he come back into custody?
Were you arrested or did you?
I was arrested, sir. My casework was supposed to call due to the weather conditions. He said he called, but I guess, but I was picked up, sir.
What were you doing when you were picked up?
trying to get to one of my friends' house. But sir, I tried to make it to court. The weather conditions was hard. I ain't have a phone. It was cold. My phone died, sir. And I tried to my my caseworker, he tried to help me too, make sure I made it to court, but he couldn't help me.
You grew up in Michigan?
You said what, sir?
Did you grow up in Michigan?
Yes, sir.
You're going to appear for our future.
If it was too cold, then we're getting soft.
Nah, it wasn't even just that. I didn't have the right clothing either, sir. And I was willing to walk
I got you.
through the distance.
I got you. I'll reinstate his previous bond. I'll grant the reduction. Reinstate his previous bond, but you better show up on the 10th. You hear me?
Yes, sir.
You got to start out walking on the 9th. You better show up on the 10th.
Yes, sir.
You call me, okay?
No, sir.
Let me just keep it real quick.
So his previous bond stated.
He right away here, boss.
Thank you, Judge. Appreciate your consideration for this young man.
Court does call the case People versus Gary Coward.
Morning again, your Honorable Court, David, on behalf of Gary Coward.
Gary Coward.
Thank you. Your Honor, myself and Mr. Chablowski are trying to resolve it at the district court level. If I can come back on the 12th, I'm back here again, Judge.
Probable cause conference without objection will be adjourned February 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Text you.
Court calls the case of the People versus Caitlin Quinn.
You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy P 33014. Take your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine. The 1-year offense upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them, and at this time, knowingly, voluntarily waived them and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep, yes, Your Honor, yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes,
and because you believe that you are indeed guilty of this offense?
yes, Your Honor.
On the date of September 4th, 2025, Washtenaw Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct between, as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge,
All right. And have I complied with the court rule?
and defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11th, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, there's. Well, go ahead, Counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail since she's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And she was hoping to, her daughter's 15 years old, she's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and to help take care of her grandmother. Her mother, I believe, is.
Are you going to be able to test clean if I let you out?
Yes, sir. I've learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing, and so she'll be released on PR.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case People versus Jennifer Burnside.
Morning, Your Honor. Jason Hagelthorne on behalf of defendant Jennifer Bernstein, who's present standing.
Morning, Your Honor.
Good morning. Your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A sobriety court. There is also a sentence agreement. Well, it just says the 14A, it says A3, but it's 14A sobriety court. Defendant has been accepted as of January 29, 2026. And there is a sentencing judge waiver checked off. That is the court's full understanding of the agreement.
Yes, Your Honor.
Yes.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service to court teams necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
I do, Your Honor.
You wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead. Anybody threaten you or coerce? You're doing this voluntarily
I am, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. And why'd they stop you?
My turn signal was burned out when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you if you commit misconduct between the time I accept your plea and the time of sentencing in this matter, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
All right. And have I complied with the court?
Yes, Your Honor.
The court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked that he has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and the release of that tether?
Response from the people.
Judge, we'd ask, being a photo manager in the next going to this Friday court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th, and then Judge Freshour.
That date can be moved up. I'm not moving it up because I don't have a date.
Fair enough.
So you guys can do that, and if you can get it moved up, then that's fine, and I'm not gonna remove the tether. Her bond will continue as is. Thank you.
Thank you, Your Honor.
I just need a form on that.
Yeah, okay.
Court does call the case People versus Marquetta Clement.
I'll come up to the people.
Good morning, Your Honor. Assistant Public.
Versus Demarion White.
Andrew Childers appearing on behalf of the people.
So,
Morning, Your Honor. Please have a court David Burgess on behalf of Marion White, who's appearing via Zoom from the Juvenile Center, Your Honor.
Mr. White, can you state your name, please?
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers are working toward a resolution. It's probably going to get bound over eventually, but we need a little more time at this level. So we're just asking for a couple weeks adjournment, Your Honor.
Okay, returning to fifth 12. All right. Probable cause conference will be adjourned to February 12th.
Thank you.
2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you, sir. Court calls the case of the people versus Margaret Patowski. Yeah. Patowski? Yeah, she's in Zoom, I think, but I need an attorney.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Patowski.
Ms. Patowski, can you state your name, please?
Sam Meeting.
And case law in there, because everything else was.
Ms. Patowski, can you state your name?
Margaret Patowski.
Thank you.
There you go.
Your Honor, there was an offer made in this matter, and I did meet with Ms. Patowski at the Department of Corrections yesterday, and as soon as I left the department, was able to leave the department and get to my cell phone. I did reach out to Mr. Childers to let him know that she intends to accept the offer. Unfortunately, I don't believe he received it in time. It was like 4 o'clock, although I had a 1:30 appointment.
I'll then adjourn this out 2 weeks to the 12th, February 12th, 2026, 9 a.m.
And I apologize, Ms. Patowski. I know you.
The bond will continue, and hopefully then I'll have the paperwork and we can get it all settled. Okay, Ms. Patowski?
Okay, thank you.
All right, thank you. Court does call the case, People versus Procopio Vitale.
Your Honor, Raymond Cook for the people. On behalf of Mr. Vitale, good morning, Judge.
Good morning.
Mr. Vitale will be approaching. Please state your name for the record once you get up here.
Procopio Vitale.
And if you wouldn't mind just signing here.
What are we doing?
Your Honor, today's date and time set for probable cause conference. We will be waiving the preliminary exam at this time. Mr. Vitale is executing a waiver form right as we speak. Handing it to Deputy Allen.
Is that correct, sir? Yes. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. I do. All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Stand mute as to reading or waive. I got there eventually.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for February 12th, 2026, 1:30, Judge Slay.
Okay, thank you, Judge.
Continued. Thank you. Calls case of the people versus Tiffany Peters.
Go on behalf of Ms. Peters. Judge, it's a turn AG case.
I think it's an AG case.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Judge, this is a PCC matter. I had a long.
Want to state your name?
Oh, I'm sorry, Robert J. Kill on behalf of Ms. Peters. Sorry about
Ms.
that.
Peters, can you state your name, please?
Tiffany Comer Peters.
Thank you.
Judge, Ms. Peters is living in West Virginia now. This is a child support matter. She's current in her payments as far as monthly payments. I'm asking for a 30-day adjournment. Again, I had a long conversation with her last night. She can make between now and then, within the next week, she can make an $800 payment. And we're hoping she can bring this amount down to where we can work this out short of a felony, but we need some time to do that.
Going to be any objection from the people regarding that?
No, I would just like the attorney to get in contact with our office, but no objection, Your Honor.
Going to call their office?
If I know who to call. Yes, I will, Judge.
Thank you. Probable cause conference will be adjourned then to February 26th.
Thank you.
Thank you, Judge.
2026.
Thank you.
9 a.m. Bond can.
Thank you. Appreciate it. This is very.
Calls the case of the people versus Gary Carmichael.
David I. Goldstein, appearing on behalf of the defendant. State your name, Gary.
Gary Carmichael, thank you.
Setting this matter for exam, Your Honor. I do have all the discussion.
That's right. People have their witnesses available to 10th,
Your Honor, I'm going to be gone the month of February.
the whole month.
Yes.
That's right. He held on something else?
No, Your Honor. I was going to make a bond motion in a moment, Your Honor, but
Are the people going to be opposing a release in this case?
I would not, I would just ask for a tether as well as a potential silver leaf.
Okay, here's what I'll do. Will March 3rd work for you?
Your Honor, I've got a trial starting on the 2nd. I can do the 10th.
So what I'll do is preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington. What I'll do at this point is I'll have his bond continued. You two send a stipulation over with the conditions and then I'll sign off.
All right, thank you.
All right.
Thank you.
Thank you. Court calls the case People versus Randall Laird. AG. This is for AG.
Morning, Your Honor. Assistant Attorney General Doris Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dottie Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird.
I need a camera, sir.
I'm working on it. I'm sorry.
What are we doing?
In regard to requesting an adjournment, I did just receive full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that on the AG case. 26. Yeah, let's do it that way. All right, probable cause conference in this case will be during February 26, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Stephan on behalf of Mr. Patton.
Mr. Patton, can you state your name, please? JudgeSimpson Patton. Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right, the plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That is correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, sir.
And that you would be sentenced before Judge Perry in the 15th District Court. You
Yes, sir.
understand that? Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No. And have I complied with the court?
Yes. You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
February 7th at 8:30 before Judge Perry.
February 27th, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
Here's the person here.
Are you going to be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Well, you're going to have to find a way to.
I can find a way.
to test. Because if I let you out, we're going to end up in the same boat again. If you don't go over there and don't test.
I can go test, sir. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated. with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
Thank you. This is what I need to do. CC order. Just want it put back to her. Court does call the case People versus Michael Padola. Yeah, I see him. Here's his attorney. Who's his attorney? Mr. Bennett? Really? Mr. Bennett? Sir, state your name.
Michael Bedolla.
I'm gonna pass your case. We gotta wait for your attorney to show up. And
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Cadena South.
And then on behalf of the people.
Your Honor, I'm sorry, did you call Bedolla? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court.
Kadena Gill Self.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th,
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see, she does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond bill, we requested 25,000 cash period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver. He had 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to his car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration, I believe, or additional charges. Calling someone names isn't enough.
Well, the
But for that's,
stabbing with a screwdriver, that would do it, wouldn't it? You don't need to say anything. Motion for bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point. Court calls case People versus Edna Grima. Grima be adjourned to February 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you, ma'am. That's called the cases of the People versus, there's a Renee Williams.
Assistant Public Defender Alexis Earth with it on behalf of Ms. Williams, who I believe is appearing via Zoom, Your Honor.
Oh, there she is. I heard her state her name. All right. Go ahead.
Is the court in receipt of the report, Your Honor, dated January 9th, I believe?
Dated January 9th to see January 28th. Yes. I have that, which indicates that she is incompetent to stand trial and likely to obtain competence
That's my understanding, Your Honor.
with treatment. All right. And do you have any other evidence at this time?
None from defense, Your Honor.
No. All right. Court will order in these cases that the defendant is incompetent but restored. I will sign an order to that effect. We'll set a competency review hearing in this matter. Yes, please.
April 30th at 9 a.m.
April 30th, 2026, 9 a.m.
Your Honor, can we briefly approach on this matter?
Sure.
Thank you.
Raymond Cook with the People.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Thomas. Mr. Thomas, would you please state your name for the record?
You're requesting adjournment for discovery.
That is correct, Your Honor.
All right. February 12th, 2026, 9 a.m. Bond continue. Thank you. Court calls case People versus Deja Banbury.
And then on behalf of People.
I'll take Daisha. She's out in the hallway. Did you get her for me, please? Your Honor, Ms. Banbury is just out in the hallway. We will, we'll bring her in.
90-day mark, April 30th. So.
Ms. Van, you have the lecture, please state your name for the record.
Good morning, Deja Banbury.
Thank you. You're requesting a forensic evaluation.
Yes, Your Honor.
All right, the court will order a forensic evaluation. I'll set a competency hearing for this matter for April 30th, 2026, 9 a.m. Bond will continue.
That'll be
Thank you.
And I'll call your mom.
Awesome. Case People versus Leo Watson.
Alexander, on behalf of people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Watson.
Your name, sir?
Leo Watson, Your Honor.
Thank you. What are we doing?
Your Honor, we'd ask the court to set this for an exam.
Discovery is complete.
Your Honor, there is some outstanding video that Ms. Zenda has told me she has uploaded. I haven't got it yet, but I have every confidence she'll get it.
If you have not received that yet, I reached out to the sheriff's department. It's surveillance footage from inside the home showing the assault. They told me they were hoping to get it today. I have not heard back yet that it has been uploaded, so I don't have that specific footage information yet.
I'd still like, Mr. Watson would still like to set the exam.
He understands that if it's not available on that date, that's not going to be the basis for an adjournment.
I have explained that to him, Judge.
You understand that, sir?
Yes, sir.
People have their witnesses available to 10. Preliminary examination in this matter will be set February 10, 2026, 9 a.m. before judge. Fresh hour.
Thank you, Your Honor. If I could be heard on bond. Your Honor, Mr. Watson is here. I don't believe he has any significant holds where he'd be picked up on them. This is a matter where he's charged with a carrying concealed weapon, a 2-year telecommunications device charge, and a domestic violence misdemeanor. The carrying concealed weapon, the allegation is that he had a over-the-counter stun gun in his pocket when he was arrested. He has significant contacts to the community. He was he reports he was to start a job soon after the date of the arrest. He reports he can stay with his sister, who I do have an address over near West Willow. I haven't been able to contact her yet, but I'd ask the court to consider, once I'm able to do that, to release him, even if the court needed to tether him, to release him with the GPS tether. Oh, and I mean, this is a situation where I believe this is a joint apartment. I think there was a no contact order for the complaining witness to not be there, actually.
Your Honor, at this point, I would object. This case involves the victim and defendant having an argument in which he took her phone, keep her from calling police. He also assaulted her by striking her in the face with a closed fist several times, pushed her to the ground, and also tried to choke her by putting her in a chokehold that she was able to escape. Officers observed the home surveillance footage that we were waiting on, showing him assaulting her. She had redness to her face, hitting his full lip, and knife use. At this point, I believe Bonner said it's appropriate. He does have a previous dismissed related charges as well as conviction from 95 out of Huntsville for robbery and sexual assault. So I think this time bond is appropriate to set.
Motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Court call case People versus Shaquille O'Neal Tubbs.
Andrew Childers appearing on behalf of people.
Ron Brown appearing on behalf of Mr. Tubbs. He's in custody, or was yesterday.
Yes.
Oh, he's on Zoom.
He's on Zoom.
State your name, Mr. Tubbs.
All right.
Your Honor, have you received a?
I received a report dated January 6th indicating that he remains still incompetent to stand trial but restorable.
Yes, Your Honor.
All right.
And I believe we submitted an order to Ms. Whedon and a Mac.
I don't think I have a new order on this. I don't have a new order. I don't know when it came in. I'll need a new order.
I'll get you one.
It's in two of the, is there one? It is, I see it. I just don't have it in the third file. All right, yes, I will, indicate that the defendant, without any other additional evidence, still remains incompetent to stand trial, but restorable. Set a review hearing April 30th, 2026, 9 a.m. Bond will continue. Thank you. Oh, what now?
This is the rest of the block.
Yeah. Courthouse case, People versus Derek White.
Assistant Public Defender Donnie Leba on behalf of Mr. White. What? You tell us your name, sir. Derek White.
All right. You're still looking for discovery in
Yes,
this?
sir. We did just receive full discovery. We just received the majority of the discovery, including the police report yesterday morning. We're still waiting for some additional information, and I would like to address bond.
Probable cause conference is adjourned February 12th, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Mr. White is currently being held on a $10,000 bond. He indicates to me he's not able to post that. This is a case that does not involve any in-person behavior. I believe this case involves text messages. He has no prior assaultive or felony offenses. He does work full-time as a delivery driver for Amazon. He tells me that both himself and his daughter are insured through that job. He's very concerned about losing that job and that insurance if he remains in custody. He does have stable local housing in Canton. He can stay out, and we have no objection to a GPS hotspot, tether, or home confinement, the ability to leave for work.
Go ahead.
At this point, I would object. This case involves victim. She had a valid PPO against Mr. White. He texted her saying, "Send me to jail if you want. This is not what I want." And then sent her a picture of a credit card with her name on it that he had taken out her name without her permission. She looked at her credit report, saw that your account recently been opened and effectively restored. There was another report later after the charges were authorized, I believe the same day that the warrant request was authorized, that he had gone to the victim's mother's house and was yelling at her about this case. So I do have concerns for her safety as well as her family's safety, and the fact that he can't follow the orders of the PPO. So at this point, I would reject any modification of bond.
Anything additional?
Sure, I would just add that I believe the home confinement tether would satisfy those concerns.
How does a home confinement tether stop him from opening a credit card? It doesn't. Motion for bond reduction to 9 bond will continue. Calls the case, People versus Cedric Blair. Good slides.
Thank you. Good morning. Joy Gaines, Senior Assistant Public Defender, representing Mr. Blair. Mr. Blair, would you state your name, please?
Cedric Blair.
Your Honor, we received an offer today. We'd like some additional time to discuss. I think we're close to a resolution.
Probable cause conference will be adjourned February 19th, 2026, 9 a.m. Bond continues. Thank you. Thank you.
Thank you.
Court calls case of People versus Janina Williams.
Your Honor, Raymond Cook with People. And Assistant Public Defender Nick Bukovich on behalf of Ms. Williams, who is now approaching. Ms. Williams, can you please state your name for the record?
Janina Williams.
Thank you. You're requesting an adjournment regarding discovery.
Yes, APA Cook was able to get discovery over to my office. I was confirmed we do have it now, so I do need time to go through it with my client, and I would like to address bond when appropriate. Your Honor.
February 12th, 2026, 9 a.m. As to bond.
As to bond, Your Honor, I would be requesting a personal reconnaissance bond on my client's behalf. She is currently in custody on a $1,000 cash surety bond. I believe the reason why the bond was put in place was due to concerns about failures to appear. This is a retail fraud first. This is a non-assaultive offense. My client's failures to appear can be traced back to a time in which she was living out of state in Kentucky, taking care of her uncle who had throat cancer. She is now residing back in Michigan for over a year, acting as a caretaker for her 7 grandchildren, and she has actually an 8th grandchild she is yet to meet. Prior to her leaving Michigan, Michigan was her home state and where she intends to continue to reside. She has no assaulted prior criminal history. In her open cases in 14B, which one is a driving misdemeanor, the other is a possession of marijuana from 2015. She has received PR bonds in both of those. She has no other holds, and I did speak to APA Cook this morning, and he indicates he would have no objection to a personal conscience bond in this matter.
And that is accurate, Your Honor. I was there at the time of the arraignment. The bond was set the way it was. There was an indication made by the magistrate at that time that if she got a PR bond on her other cases, that PR bond would be appropriate here. I do see that she has a PR bond on her other cases. I would have no objection to her having a PR bond on this case.
Personal recognizance bond. Thank you.
That's a PR bond.
Thank you.
Yes, maybe after. Thank you, Your Honor.
Thank you.
You're welcome, ma'am. Court calls case of the people versus Jessica Briscalia.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf Ms. Brisgala, who I believe should be appearing on Zoom.
Gala, oh boy. Need you to unmute and state your name.
Okay, hi, can you hear me?
Yeah, we can hear you.
Okay, Jessica Briscoe.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's gonna need to, let me just stop you. She's gonna need to appear in person. We've had a problem with this defendant. We've kicked her out of our courtroom. I think on 2 occasions. She's come back in. She was smoking.
That wasn't me.
Folks. My staff has reported that was you. And
No,
it
that-
appeared as though you were having sex on the screen.
No.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my
okay.
staff reported it to me, and it did appear that that's what was occurring. So what I am going to do, not on the defendant's motion, I'm going to adjourn this out to next week, the 5th. You'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.
Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my court. Okay, it really wasn't all that exciting. I just so everybody. Court does call the case. People versus Daenerys Williams.
Jacob Kennedy for the Michael Kennedy, defender for Mr. Williams, Your Honor. He's approaching the podium.
Yes, he is. Your name, sir?
Denard Williams.
Thank you. You're seeking an adjournment.
Yes, Your Honor. There's some more discovery that kind of is somewhere between us and them.
That's correct, Your Honor. It's in the cloud.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you,
I'll
sir.
come.
Charles case, people versus Xavier Braxton.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Braxton, who should be appearing via Zoom.
Oh, there he is. Xavier Braxton. You need to unmute, state your name. Mr. Braxton, state your name. He can't hear us. How did he know if he can't hear us?
I did.
Oh, you prompted him.
Oh.
We can hear you now. State your name. He can't. He's there, but he can't hear us. So can we just type to him for him to state his name? Just say your name. I don't need, really, man, just. Just say your name.
I just sent him a text.
You're
message.
requesting an adjournment.
Yes, I am. Yeah.
All right, I'm gonna adjourn this matter to February 19th, 2026, 9 a.m. Can you type that to him? So apparently he can see that his bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Bernard Brock.
Is he on Zoom?
No. He's not on time.
I've been calling him.
Pardon?
I've been calling him.
Okay. Bench warrant will issue for defendant's failure to pay your bond, set the amount of $10,000 cash surety. That warrant will issue immediately. Court calls the case of the People versus Corey Brown.
Your Honor, Raymond Cook for the people.
Michael Gaddy, Assistant Public Defender for Mr. Brown, Your Honor.
Corey Brown, not present.
No, Your Honor, I talked to him Tuesday at around 3:45. He said that he's not feeling well, was going to the ER. I have not heard from him since.
He also has a community corrections violation.
Complete coincidence, Judge.
Yeah. Bench warrant will issue bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Rick Artuso.
Your Honor, Raymond Cook for the people.
Oh, he's here.
The public defender, Chinazi Carey, I can rule Your Honor on behalf of Mr. Artuso, who's approaching. Mr. Artuso, state your name for the record.
Artuso? This defendant actually did the right thing. He was running late. He called the court.
That's right.
Came in so that everybody would know that he was, and he gave an approximate estimation of time, and he got here.
Good job, Mr. Artuso.
I appreciate it. All right, what are we doing?
Your Honor, we'd like to set this matter for preliminary examination
Discovery is complete.
to our knowledge, Judge.
All right. And would the people have their witnesses available to attend?
Sure, Your Honor.
All right. Preliminary examination in person in this matter will be February 10th, 2026, 9 a.m. That is before Judge Freshour.
Thank you, Judge.
Bond will continue. Yeah, go ahead.
I actually was scheduled for probation on February 10th.
Scheduled.
time?
What do you mean?
In circuit court?
Yeah, from circuit court.
Okay.
From cases before.
I can email them and let them know.
Okay, I was just letting you know.
Okay, so,
He's got a circuit court matter with me, Judge, so I will.
oh,
yeah,
okay.
I will
I
let you
got
know.
it. I got it. Okay, thank you, sir.
Okay.
Court calls the case People versus David Brown.
People, Your Honor.
Joy King, Senior Assistant Public Defender representing Mr. Brown. Your Honor, I've called Mr. Brown's name several times in the courtroom and I not received a response.
The defendant having failed to appear, I'll leave the community corrections bench warrant outstanding.
Thank you, Your Honor.
All right. Wow.
Thank you, Your Honor.
Court calls the case People versus Linda Bryant.
Your Honor, Assistant Public Defender, and on behalf of Ms. Bryant, who's approaching, can you please state your full name for the record?
Linda Bryant,
Thank you.
how you doing?
I'm doing well, miss.
Your Honor, we're
Good.
asking for this matter to be set for preliminary examination.
Here I am again.
What you said?
Here I am again.
Here you are
Another
again.
postponement. You see, it's getting harder and harder for me to get up in here. I tell you.
But you made it.
She made
Yes,
it.
I did. Grace, by the grace of God.
Discovery is complete. Will people
mine.
have their witnesses available to 10? Yes. All right. Preliminary examination in this matter will be in person February 10th, 2026, 9 a.m. before Judge Garwood.
I have a question. But then, they say they have witnesses.
Yes, I'm sure they do.
Oh, I don't think so.
Okay.
But okay.
Thank you.
Okay, thank you.
Your
You guys have a good day.
You do the same. Court calls case People versus Amaya Campbell.
Michael Gaddy, Assistant Public Defender for Ms. Campbell, Judge. She should be here via Zoom.
I think she is. Ms. Campbell, can you state your name, please?
Amaya Campbell.
There she is.
Your Honor, we're asking to adjourn this matter 1 week. Mr. Childers has made an offer. I've had a chance to discuss it briefly with Ms. Campbell, but we need some time to put the paperwork together to complete the plea.
February 12th, 2026. Bond continued.
Thank you, Judge.
Court calls case People versus Jason Campbell.
Assistant Public Defender Davi Leba for Mr. Campbell, who is not present. I had been attempting to reach Mr. Campbell. He reached out to me this morning and indicated he was in treatment and unable to attend. I did ask him to provide me some documentation of that. Unfortunately, I did not hear back from this morning. However, given that he was in treatment last time and indicates the same to me today, I would ask the court to consider an adjournment.
And court will issue bond set in the amount of $10,000 cash surety. That warrant, he needs to get that information to the court. That warrant will issue this Friday, the 30th.
Thank you, Your Honor. See if we can get that.
Court calls case People versus Zion Cheatham.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cheatham, who should be appearing via Zoom.
State your name, Mr. Cheatham.
Zion Cheatham.
Thank you.
At this time, Your Honor, we're seeking an adjournment to finish up negotiations. A mitigation report has been provided to the prosecution for their review.
Probable cause conference, February 19th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case, recalls the case, People versus Michael Bedoya.
Good morning, Your Honor. Samuel Bannerpring on behalf of Michael Bedola, who's appearing via Zoom. We waiver in-person appearance, have no objection to Zoom. Sorry, I missed you the first time, Judge. I had a few other Zooms going at the same time.
Sir, can you state your name, please?
Michael Bedola.
Okay. First thing is, counsel, you're going to need to file, because there was an attorney already on the case. I need a substitution of a.
Yes, Your Honor, that's been
counsel.
sent over earlier this morning, so it'll get in the file soon, I think. And Your Honor, with regard to the PCC, I'm asking for one additional PCC so I can meet with my client, review the discovery, and get in touch with the prosecutor, Mr. Kennedy, on the case. If we could do the 26th of February, that would be great. I have a couple trials coming up.
Not that I'd let you pick your date, since you don't appear anyway when I call the case. Counsel, any objection?
No objection. Your Honor, thank you.
February 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Have a great day.
Thank you.
You too.
Thank you.
Court calls the case of the People versus Deborah Collette.
Assistant Public Defender Alexis Zerps with and on behalf of Ms. Collette, who should be present via Zoom. Ms. Collette, can you unmute and state your name for the record?
Which one is she? Samson. Ms. Collette, do you have somebody that can help you unmute? Oh. She's trying. Oh, you got
Hello,
it.
hi. Hello.
Hello. State your
Hi,
name.
Good morning, Your Honor. My name is Deborah Joanne Collette.
All righty, thank you. All right, what are we doing?
Your Honor, we're still waiting on some documentation from Ms. Collette for us to be able to provide to the people in preparation for some plea discussion. So we'd be asking for an adjournment.
So you're waiting for information from your client?
Correct. And we would turn that
So
over.
that you can turn it over.
Yep.
Gotcha. All right.
And Your Honor, if you wouldn't mind going out a little bit longer, Ms. Collette did just recently move, so she's trying to get some affairs in order, so it's taking her a while to get a hold of these documents.
February 26, 2026, 9 a.m. without objection. Bond will continue.
Thank you, Your Honor.
Oh, sorry. I'm sorry.
Thank you, Ms. Collette. Court calls case, People versus John Brooks.
Good morning, Your Honor. Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Brooks. Would you state your name, sir?
John Brooks. Thank you. What are we doing?
Your Honor, I have a plea form and advice of rights here. The prosecutor has agreed that if he pleads to counts 2 and 3, they will dismiss count 1. Restitution is still being worked out, the exact number, but we understand that that will happen at sentencing.
Please agree with the restitution on all charges counts, or all counts.
All right, I have a plea form now before me that indicates that the defendant is going to be pleading guilty to 2 misdemeanors, malicious destruction of a building, 1 count of 200 to 1,000, a 1-year offense, and then malicious destruction of a building less than 200 to 93-day offense. Upon his successful plea to that charge, count 1 would be.
She thought she had an explanation, but the judge wasn't buying it. This courtroom hearing started with what seemed like a routine progress review. The defendant was out on bond and trying to stay in compliance with the court's conditions. But one issue immediately caught the judge's attention. She had tested positive for cocaine. When the judge asked about it, the defendant insisted there was an explanation. She claimed she had struggled with cocaine addiction for decades and argued that the drug could still be showing up in her system from earlier use. At first, the judge listened carefully. He gave her every opportunity to explain. But the more questions he asked, the more her story began to fall apart. The judge pointed out that she had first tested positive, then missed a required drug test, and later tested positive again nearly 2 weeks afterward. He asked a simple question. If she hadn't used cocaine again, why was she still testing positive? The defendant tried to explain that the court wasn't looking at the drug levels in her system. She insisted the results didn't necessarily mean she had used cocaine again. The judge wasn't convinced. He explained that the timeline simply didn't match what she was claiming, especially after she had missed one of her required tests. Then the courtroom took another turn. A voice from the gallery interrupted the hearing. Without hesitation, the